getting married is an exciting step, and a prenup could be the right choice for you, and we're here to help. Please use the Q&A feature to submit your general comments and questions about this topic. For specific questions about the details of your family law matter, please contact our team directly. The purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be construed as legal advice. Stay tuned until the end, as we will be sharing how you can schedule a free initial consultation with one of our lawyers. My name is Natalie Derbyshire. I was called to the Bar of Ontario in 2006. I provide clients with peace of mind through sound legal advice and help them navigate separations confidently. Focusing on dispute resolution processes like collaboration, mediation, and negotiation, I aim to save clients money and achieve reasonable settlements. Specializing in supporting vulnerable clients, particularly those affected by family violence, I offer legal knowledge, safety measures, and therapeutic resources. I've been practicing as a certified collaborative practitioner since 2011. And joining me is my mentor and friend, Ellen Nightingale. Welcome. She has been a family law lawyer for 45 years. Her practice is located in Toronto, and she is devoted to resolving conflict by peaceful means. She is a board member of Ontario Association of Collaborative Professionals, known as OACP, and past chair of Collaborative Divorce Toronto, also known as CDT. Her services enable clients to create wise, customized solutions, maintain important relationships, and provide peace of mind. So welcome, Ellen. Thank you for joining me.
It's a pleasure to be here with you this evening, and thank you for asking me.
Thank you. So, Ellen, just to quickly get into our very juicy topic of this evening, pros and cons of signing a prenuptial agreement. Might you be willing to comment upon why you find this topic so appealing, or why you're passionate about it?
As a matter of fact, I do, really, because I see these kinds of conversations as recognizing that what started out as romance becomes reality. And we know that a marriage will end and a common law relationship will end. They have to end, either because there was a breakdown in the relationship or the marriage, and we call that a separation, or because one of the spouses passed away and the marriage or the common law relationship ended at that point, but it will end. And so there's an opportunity that some folks might take to plan for the end of the relationship. I like to approach it as a plan for success as opposed to a plan for failure. The difference being that a plan for success recognizes who the parties are and honors the relationship, regardless of how it ends. A plan for failure is simply a doomsday series of decisions that if we fail at this, this is what you get and this is what I get, without really taking into account who the people are, what they hope for, and how to make for an enduring relationship because they took the time to understand each other, hopes and fears, and to honor the relationship. So this is something I do a lot of. Not all family law lawyers like you and I, Natalie, do these. They can be complicated, and it's a lot of crystal balling and helping folks be true to themselves in terms of what they have, what they want, what they fear, what they hope for. And I always enjoy working with you.
Thank you. And I will say the same. I always enjoy working with you because I know I can trust fall with you. And I think that's important as collaborative counsel. These topics tend to be sometimes emotionally triggering, but I think it helpful ultimately in the end for people to have a plan and to know where they each stand and whether they're on the same page before embarking on a long-term relationship with one another.
At the very least, you and I have found that although folks think they want to do a marriage contract or a cohabitation agreement, once they get started, they decide that it's not something that feels right. And at the very least, what they have done is they have exchanged financial information about each other so that they know who they are living with or going to marry, and there are no surprises. And they also have the benefit of having had a Law 101 tutorial to
A
help them.
boot camp.
Yeah, really, marriage contract boot camp, prenup boot camp, that this is what you can expect will happen if the relationship or marriage ends in 5 years, 10 years, 25 years, and you don't have this contract in place. And frankly, I think anyone getting together to get married or simply live together should be required to do this boot camp 101 just so they know what will happen in the end, that common law relationships don't turn into marriage contracts and into marriages rather, regardless of how long you're together. They don't morph, they're always different. So
I couldn't agree more.
that's a benefit, even if they don't do them. But that's something else altogether. So we have some things to talk about today. Um, and so maybe I'll just ask you a very general question, Natalie. What do you think the purpose of these contracts are? Why would I want to talk about it with my beloved and the lawyers?
So, anybody who actually cares to learn about Family Law 101 or engage in a premarital or a pre-cohabitation boot camp, as we say, may be somewhat, I will say, shocked by what the law provides for in the event of a breakdown in the relationship. And so the purpose of a marriage contract or a cohabitation agreement is to be able to maintain control over the outcome as to what will happen in the event that you experience a breakdown of the relationship, either by way of death of a spouse or by way of separation. And so it's our goal to help empower you to potentially modify any legal rights or entitlements that may be prescribed by law in Ontario, or ultimately waive or limit rights or obligations that might otherwise arise, but for the existence of a contract.
So what I
And
think I hear you saying is that a contract like this will either modify or not modify, which means to accept whatever the law and the circumstances and the facts at the time may be. Your entitlements to property,
that's right.
assets and liabilities, and entitlement to spousal support.
Spousal support,
Right, okay. Whether they
100%.
happen, whether it ends because there was a death of a spouse that ended the relationship or the marriage, or because there was a breakdown and a separation. So that's the purpose. The purpose is to either modify or not modify property entitlements and spousal support.
That's right. If I
So,
can put it a different way, it's to enable people to author the next chapter of their lives in the event of a breakdown of the relationship.
I like that. Yeah,
Thank you.
I like that. Um, I have a client who recently shared with me what she and her fiance, and these are both going into second marriages now, one with adult children and one with not, that I'd love to share. And she said that this process isn't only about negotiating terms, it's about creating a kind of justice that reflects who we are. to your point of authoring what it is that we hope to achieve over the course of their relationship, because she says, we want to build something here.
I love that.
We want more than legal protection. We want peace of mind. This agreement is our way of saying, I see you, I understand you, and I won't harm you. So you and I, we are like-minded in that we encourage our clients to apply that kind of thinking to their authoring, and not just, this is mine, this is yours, and thanks for everything, and goodbye.
That's profound, Ellen.
Yeah,
I love,
yes, I don't, I care very much about this client, and I think she and her fiance are really doing some hard work to understand each other's fears and hopes, without putting a knife in the relationship. Because I happen to think, and I know you do as well, that the more you know about your partner, the more you can help them feel safe.
absolutely. And
Emotion.
I love that they want to honor their own autonomy. That's key too, right? To be able to not only listen to one another and understand one another, but actually take heed of their respective goals and interests
And fears.
and fears. Yes.
And fears, yeah. So let me tell you, perhaps, since I know your next question is going to be, what can't go into these contracts? Now that we know what can go into these contracts. And some folks might be surprised to hear this, but anything having to do with children. You can't talk about what a parenting schedule will look like if there are children, or even if there are children already in the future. You can't say, if we separate, that I keep Johnny because he's mine and you'll never see Johnny again. Okay, you can't do that. You can't include information about who's making decisions about children that exist or may exist in the future, how you will raise them, moral training, religious training, those kinds of things. Child support. Can't talk about who's paying it, to whom, and in what amount. Child support is the right of the child in any event. It's not the right of the recipient parent. Something that doesn't go into this, and certainly you and I never do, is that how expenses are to be shared. I'm making the
Right.
mortgage payments, and you're taking us out for dinner, and we're sharing the travel, and because it can be nothing more than intent. Over the course of a relationship, someone might lose his or her job, or
Things change.
suffer a disability, or have to financially support a parent or a relative. And so it's not a book of rules that I
Mm.
take out the garbage and you buy the groceries. That's not what this is about at all.
Thank goodness for that.
Yeah. And also, there is no punishing for bad behavior in here, so that the result for the husband messing around is not different from the result if the wife messes around. In law in Canada, fault is not relevant to entitlement, whether it relates to spousal support or the division of property, equalizing property. So we don't put it in these contracts either. And
Correct.
I describe that as punishing bad behavior, because really it takes two to tango,
It really does.
doesn't it?
And I mean, it's so common, sadly, right? I would say infidelity is one of the major causes or reasons for separation or breakdown of the relationship. So
And yet it's almost never one person's fault for straying. It was the relationship. Right.
all the more reason why a collaborative process is helpful in uncovering all of these things so that both people can understand their part in how the relationship unfolded. But
Hmm? Right. You're
that's
talking about separation agreements once
yeah,
they go sideways. Right. Yes. So
right.
it takes a team of caring professionals to help folks own what happened and not just who gets the house and who gets the cottage and who gets the money, right? Okay, so is there more than one way to negotiate or come to conclusions as to what terms go into these contracts, Natalie? What?
There are a few processes that you may want to consider when you're looking at potentially getting a cohabitation or marriage contract. The first, which I cannot recommend, is preparing what's called a kitchen table agreement. And this is where the two partners decide to enter into a written agreement without legal advice and without the assistance of a lawyer drafting the agreement for them. This has many pitfalls. I don't know that we have time to cover all of them today, but that is one option available to people, which sadly can lead to catastrophe down the road. I don't know if you want to add to that briefly,
What does
Ellen,
the
or if
catastrophe mean? Do you mean by in catastrophe that the relationship ends, or the marriage ends, or that the document gets challenged
well, both, I
and now
suppose.
there's litigation?
I was thinking if the agreement got challenged, it would certainly pose difficulties for the couple. But point taken, it can also be very difficult if there's a separation period because interpretation is everything. And sometimes layman's drafting is not particularly clear, and there may be differences of opinion about how to interpret the kitchen table agreement itself.
And there could be coercion and power imbalance, and one person either not understanding or not feeling like he or she has a voice to say, no, this doesn't work for me. And then suddenly it's signed, and um, whatever whatever reluctance a partner felt at the kitchen table bleeds into the relationship and likely has something to do with whether that relationship succeeds or
It
fails.
sets a tone, doesn't
Right,
it?
doesn't it?
Yes.
All right. So how else? You got a kitchen table. We don't like that. What other way do you think?
Process. So, another way that I've seen occur, sadly, in my practice is one spouse or partner may be given a draft contract by the other spouse without having had any say about the terms in the contract or without having had a voice at the table to help develop the contract itself. And this is, as you noted, Ellen, the type of situation in which there's a power imbalance. And often people in this situation feel coerced or under undue pressure to sign the contract. And these are the types of agreements I see sadly arise at the 11th hour before the wedding date. So this is where people feel, significant pressure to sign or else uh, perhaps not get married. The third process is traditional negotiation, and this is where counsel are retained by both partners to receive independent legal advice. An agreement is drafted by one of the lawyers, the other lawyer reviews it, may provide proposed changes to it or track changes, and ultimately they come to a meeting of the minds via negotiation. The third is via mediation, and this is where there's a neutral facilitator of discussion who helps the parties try to reach a middle ground, so to speak, or a meeting of the minds with respect to what they would like the outcome to be in terms of property division and or spousal support if there is a breakdown of the relationship.
And why
And
why why might mediation fail um, based on the personalities and the communication styles of the parties? You talked about the mediator's role is to get them to try and come to an agreement. Is it
Mhm.
possible that even the mediator can't facilitate a circus?
I would say it is, and I've seen it occur in situations in particular where one partner is not as financially savvy as the other. They could benefit from the assistance of a neutral financial professional, assisting them with both understanding full financial disclosure from the other spouse, interpreting what a division of property could look like in the future, perhaps doing some financial forecasting, and understanding the difference in terms of lifestyle that future children might experience in both homes if there isn't an equal or near equal division of the net family income of the family. So in those circumstances, I think it's possible for a mediation to fail because the benefit of an expert financial professional or a family professional giving a partner a voice if there's a power imbalance or one is more submissive perhaps than the other, who's maybe more extroverted or more outspoken or opinionated. It's in those circumstances in which they may be able to better achieve a final deal if they only have the necessary supports available to them.
And I'm going to suggest, Natalie, that being accountable to your own lawyer and not just trying to put something over on a neutral who has to be a neutral, that's the mediator with allegiances to neither of the
Right.
spouses, is going to ensure that parties to these conversations are managed by their own lawyers, which doesn't happen in mediation, doesn't happen at the kitchen table. Um, can happen in traditional negotiations if the lawyer doesn't believe absolutely everything that the client says to him or her and
Yes.
more questions and suggests perhaps that what the client wants, your own client wants, is unbalanced. So even in traditional negotiations where it's just a lot of paper flying back and forth, you don't have the support that you might need. And so now you're going to come to us with the fifth process, which is the one that you and I use all the time,
Subscribe to.
and and
Absolutely.
and trust. And what is that?
Wholeheartedly. It is the collaborative family law process. And in that process, we work as collaborative practitioners to ensure that both spouses feel heard. They're actively listening to one another. We're helping them in terms of engaging in civil, respectful, and meaningful conversation. And typically, we have two professionals at the table with us. One is a financial professional who's neutral to the parties, assisting them with understanding things like budgeting, tax consequences, cost effectiveness of certain options or solutions, as well as I said, financial forecasting and calculating spousal support in terms of the amount to be paid and the duration that it will be paid for, as well as sourcing payments. If there are obligations to pay the other spouse, it can be helpful to have that financial professional give them advice about where to best source those funds from in order to make the payment with minimal tax harm, if that makes sense.
And yes, and because full complete financial disclosure is required, somebody has to collect it and put it all together. And when lawyers do it, it typically costs more than the than the family law financial professional who's collecting it and putting it in usable form at a lower hourly rate and shared cost by the parties. And I think you're also suggesting that sometimes where a real power imbalance is apparent early on to the two lawyers, that a family professional be brought in to help folks plan for success,
Absolutely, because
not for failure.
yeah, they don't always appreciate what both of them are bringing to the table and why what they are proposing to do or what their role will be during the relationship is of importance or value. And so that family professional can be key in having people see things from one another's perspectives
Yeah.
and also giving both partners a voice, a much needed voice.
All right. Well, I think we probably have covered off what we believe to be the chances of failure or a success of the relationship based on the process that the parties choose. Because starting from the worst possible way to do it, which is the kitchen table, take it or leave it, and I know more, and this is fair, and you don't know what you're talking about, and here, sign here. And don't worry, you can trust me, I'll take care of you. Um, and for my money is not a good indicator of the success. And building up from the lowest to the best into giving somebody the contract at outside the church also not doesn't bode well for a healthy, durable relationship. So I believe, and I think you would agree, that honoring people as they come into our relationship using a process that honors their conversations hopefully gives them a better chance. It doesn't ensure, but it gives them a better chance of weathering life's storms because they started out being a little more vulnerable and a little more aware of who they are and who their partner is.
And I'll add to that, Ellen, that I think by offering the collaborative process, we're avoiding the potential of broken telephone. Because in too many processes, we see counsel simply being unaware of specific facts that maybe their client either forgot to provide to them or omitted intentionally.
Purpose?
And and the openness and the transparency of the collaborative team is what really enables us to do our best work, I feel.
I know it. We all have skin in the game when we're doing this kind of work, and it's whether you're helping folks on the way in or the way out, they're already married and it's, and it didn't work. That it really is the only way, in my opinion, to respect people and um, explore the depths of their differences in a respectful way. And this is the
And
only.
it's no way to enter a relationship based on false pretenses, right? We need that fulsome knowledge
And
of one
fear,
another's,
and fear,
sorry,
and fear, being afraid to ask,
maybe, right?
right? And
And
not
it's
rocking the
it's
boat.
it's such a leap of faith, I suppose, that I'm trying to say, that it really helps to know that that person is willing to be 100% transparent with you from the outset with a view to achieving success down the road.
So fast forward, we've had discussions. The parties have had discussions, not necessarily in the collaborative forum, but somehow or other this contract got signed, and in at some point in the future, on a separation, one party decides that he or she is not happy with the document and wants to challenge it. And the way to challenge it is to go to court with the necessary documentation to say that I'm asking the court to set aside all of it, some of it, and this is why I am asking the court to set it aside, and we call that challenges. So why do you think these contracts get challenged?
Well, more often than not, I see them getting challenged because under Section 56, Paragraph 4 of the Family Law Act, they can be challenged if there was not fulsome financial disclosure at the time of entering into the contract.
Mhm.
So this may include a lack of information about assets, debts, or liabilities, as well as income at the time that the parties contracted with one
Right.
another. It may also be because one or both parties did not have independent legal advice.
Mhm.
So they didn't have the benefit of understanding from counsel what the nature and consequences of the agreement were at the time of signing it, or understanding what their legal rights and entitlements or obligations could be by law at the time of signing it or at the time of the breakdown of the relationship.
I would imagine that this ILA feature, which is what you're talking about, independent legal advice, also comes into play if the document is in draft form is provided to the lawyer simply for ILA at the end. And so while both parties had that ILA sign off, that one or that at least one lawyer was not ever involved in any of the negotiations, has no context, and is now suddenly looking at a document that the new client is very happy with, wants to sign it, and really, there's no way that that lawyer knew whether there was informed consent or not. So it could also be a matter of there being ILA, but last minute ILA, which isn't.
And when they come to me at that stage, that's when I have heart
Yeah, and
palpitations.
then I won't do them. I won't do those.
So
So
we missed a few steps along the way.
yeah,
We
yeah,
missed, right? We missed the financial disclosure step. We missed the
right.
negotiation or
Goals and
discussion.
interests.
Absolutely,
Yeah,
right?
right.
And you're really missing the mark in terms of balance, equality, fairness, justice, right? We want people to be ideally entering into these contracts on an equal or level playing field insofar as possible.
So, do they get challenged, you think, also in a general sense that couples are reluctant to put enough time and thought into it? They don't want to do the hard work?
I will say yes, I've seen that occur when people think it should be easier than what we
Right,
suggest it actually is,
right.
because they don't want to spend the time, money, or energy taking a deeper dive, so to speak. But I will say that those who heed what we have to advise typically are much more satisfied with the overall result because they've had the in-depth conversation with their spouse. They have a better, fuller understanding of one another, and they feel much more confident about embarking on a path together that they maybe once was murky, if that makes sense.
Hmm?
It's possible that when people are entering into a relationship, they both have two very separate, distinct visions in their mind of how things will unfold. And that conversation, that collaborative discussion is often what helps people set the tone for how they'll resolve disputes and issues moving forward.
I have a rule. I had a rule, rather, that I would not take on a client who wants a marriage contract where the wedding date is fewer than 4 months from the date we get started. My rule now is 6 months. So if you come to
Bravo.
me, that's if you want to get married July the 1st, you better be in my office on January the 1st, because I don't want there ever to be the smell of duress on a challenge in the future, that the guest list was cemented and the musicians had been paid and we're running out of time and we're running into snags. Do you have a rule that looks anything like that?
Absolutely. I am the person who will decline the file when there is not enough time to give people the um information and the ability to make very important decisions that will impact the rest of their lives, potentially. If there's not enough time for them to do that, then I am the lawyer that will say, I am not the lawyer for you.
Right. Yeah, well, like me. And so what do you think parties can do to maximize the likelihood that a challenge will fail?
So there's a few things they can do. One, I feel strongly they can enter into the collaborative process because I feel that is the process in which they're likely to garner the most information and insight about their partner and about their respective goals, preferences, interests, and as you said, Ellen, fears. So it's the process in which you're able to be vulnerable and you should be vulnerable and thoughtful in your discussions with one another. It really opens the door to creating a sound way of communicating with one another and problem solving from that point forward. Another way in which they could potentially avoid a challenge to a contract in the future is certainly by providing fulsome financial disclosure to one another. As I said before, being transparent is key in getting to the finish line and ensuring that the contract is as airtight as possible. So they must provide information about their income at the times of entering into the agreement, the value of their assets, their debts, and their other liabilities. And by doing that, they're giving each other a full financial picture that enables one another to enter into the contract with what we call informed consent.
So,
Um,
go ahead.
and then apart from that, I think what the family and the financial professionals do very well in the collaborative process is they enable both partners to see the perspective of the other in a way that they might not, but for them providing that insight or that input. And so I think it important for them to put themselves in the shoes of their partner and understand all of the fact scenarios that we've seen in the past, Ellen, throughout our legal experience, where down the road, people don't necessarily envision that there may be a disability or an illness, or as you said, elderly dependent that they need to take care of, or job loss of
Or
some description.
children, when somebody is waiving the ability to seek spousal support and suddenly there are three children. Okay,
Absolutely.
right.
And so it's our job to turn their minds to those potential circumstances, as remote as they may think they are, so that they can potentially understand how that contract will impact them regardless of the scenario.
Would it be fair to say that when a challenge is launched, that the reason a person asks to challenge the document is because they would not have signed it had they known. I didn't know, I didn't turn my attention to, I didn't have that information. Um, it's really the case law is such that it's clear that I didn't know. And had I known, and so something that I do quite often is, and I think you and I may have done it in unusual resolutions, is to prepare something called a term sheet that counsel prepare that the clients approve and vet and sign, almost like, minutes of settlement, that this is what's going into the marriage contract before it gets drafted. And that is something that comes out of the collaborative process and everyone wanting to ensure that everybody is protected, everybody knows what's going on and is providing informed consent so that a challenge will not be launched. Nobody wants to be a party to a document that they believe has a weak link. and
Absolutely.
could be set aside, absolutely contrary to what the intentions of the parties were when they signed it at the time.
And I think that helps avoid a Levan and Levan situation as well for
That's a
anybody
case
interested.
you're referring to a very famous Ontario case.
That's right.
That's right.
But so I think by having evidence of those collaborative conversations and what was discussed is actually key to supporting that both people entered into the contract with complete autonomy and say without having been subject to undue pressure, duress, or coercion.
And eyes wide open. Right.
Exactly.
Right. I have another question for you. I see we're coming up to the last quarter of the session. And folks, if you have questions, I've been scanning the chat feature here and I don't see any, and we can't see your faces, so we don't know if you're raising your hands and there's something that wasn't clear. But let us know if there are any things that you would like to know about or that we were not clear about. Natalie, what do you think you will do or would do if you look forward early on in a file and you come to see or suspect that the parties are going to agree on something? There is going to be consensus, but what they're going to agree to is shaping up to be what you think an unbalanced contract, one that really favors one over the other. What do you do in the early stages of seeing where this may be heading?
So the first thing I would do is have a very candid conversation directly with my client about potential pitfalls I see, concerns that I have, or issues that may arise or have already arisen that they may be unaware of. By alerting them to those issues and those concerns, my hope will be that they will instruct me to act or make requests in such a way that will best suit their needs and interests. If it seems that they are adamant to still waive rights and entitlements, and I think it's highly imbalanced, my hope is I would be in a collaborative family law process so that I can hopefully have a trust fall with my collaborative team and inform them of my personal concerns about the imbalanced nature of the contract or the proposed contract.
Okay, so I'm going to play the devil's advocate because you might be acting for the spouse who is the winner take all,
Could be,
and it's unbalanced in favor of your client
yes.
and not in favor of mine. Are you still bringing to the table that concern about an unbalanced resolution? And if so, why?
I would still want to probe my client first and foremost, and perhaps the team to see how they're feeling about the contract. There are ways in which you can test the temperature of the room, so to speak, and see if people are feeling at all uncomfortable or awkward with what's being proposed, and hopefully garnering some trust from those people by raising um, or at least probing them for their thoughts and feelings. So I would probably start by doing that and asking, does this feel right to everybody without necessarily pinpointing the concern or the issue that I have seen or suspect may be problematic?
Um, you and I know that in this process, which is unique in its approach and the teamwork, that if I'm having trouble with my client, I can come to you to help manage my client and manage your client at the same time so that mine will be easier to manage. And by that, I mean, if you have the client who wants to take all, and I have the client that is prepared to give all,
Mm,
That's the unbalance. You might come to me with some questions and perhaps coaching on to uh, how to help your client see things differently and
yes,
be more generous or to be more mindful or less fearful, which is completely appropriate in a process like that. It doesn't mean you're not taking care of your client and I'm not taking care of mine. Uh,
right.
but I would come to you if I have the one that's about to lose it all at the end of a marriage. I would come to you and say, I'm looking for ways I can't seem to reach her, it's typically a her. And so it's a lovely way to ensure that we are doing our best for our clients by helping each other manage our own clients to get the best results without worrying that we are in a position of conflict, that I'm not taking care of my client and I'm favoring yours or vice versa, because we're working as a team and we
Well,
want to.
and I would add to that, we're not doing them any favors by drafting and signing an agreement that is highly imbalanced
So
or
why?
unfair,
So,
because
so, so why is that? Why?
that is a ground upon which the domestic
Right.
contract can also be set aside.
Yeah.
If it is, as we say, unconscionable or grossly unfair, it's quite possible that the court will set aside, I'm so sorry, all of the agreement or part of it.
Mm-hmm. So I know of lawyers who will not continue through on a file with a client where he or she is giving it all up and it is so unbalanced that the lawyer will not provide independent legal advice and will recuse herself or himself from the file because she doesn't want to be, or he, a party to an agreement, knowing that it is so likely to be successfully challenged in the future if someone seeks to challenge it.
Right. And I would also say that is the benefit of having a family and a financial professional at the table because often, thankfully, they spot these issues from a mile away and they don't leave it to counsel to broach these difficult issues. They will literally bring it to the table and say, this looks, it doesn't pass the sniff test,
Right.
so to speak. It looks a little skewed in one person's favor. And what can we do about this to make sure that both people walk away from this feeling like they've achieved a win-win?
So we know that these contracts are not easy to negotiate. We know that they can be tricky. We know that doing the hard work and rolling up your sleeves as a team, including the clients, is the only way to ensure that that you've built a good, solid plan, a roadmap. So with that, how would you give comfort to a potential client as to the benefits of adding neutrals, financial and family neutrals, to a team insofar as additional cost or not? Is it the right person doing the right job at the right time? And the investment in the product that you're building.
So firstly, I'll say it may not be an additional cost. Often it seems that way because there are four professionals charging their respective hourly rates. But as you noted earlier, the financial professional often charges a much lower hourly rate than the lawyers would for reviewing all of the financial documents, bank statements, investment statements, etc.,
Right,
and compiling the financial statement which is needed as evidence. It's typically appended as a schedule
right.
to the marriage contract or the cohabitation agreement to show or support that both parties had full financial information before they signed the contract. And so I sell it to people, and frankly, it often sells itself, simply based on the lower hourly rate of the financial professional and the fact that they are one person, not two, gathering all of the documents of both spouses, and therefore they're best situated in order to get a full view, bird's eye view, so to speak, of the entire matter and the financial picture in a way that the lawyers can't appreciate, at least initially. And so by doing that, the financial professional is able to then impart the information to both counsel in a neutral and even way, which I find very helpful because sometimes when we're receiving only one side of the financial picture, we get a very skewed view of how things look or how they might unfold. And sometimes we're surprised by the financial information that comes through from the other side down the road. So by getting all of that information at once from one professional, we're actually benefiting the clients from a time efficiency perspective as well as cost effectiveness perspective.
So what I hear you saying is that you don't get a durable product if cheap and fast is all you're looking for.
Cheap and fast is foolhardy
Yeah.
and potentially very costly down the road. You may not appreciate or understand the financial consequences up front, but they may be hefty down the road.
And while you are, I think now referring to a breakdown
Yes,
as a result of a separation agreement, I would imagine that cheap and fast also ensures that you fall into the pit of not knowing anything about your partner, having a power imbalance, not having a voice heard, and being an unhappy spouse because
precisely.
you started
In a nutshell,
that way.
Ellen.
Started that way. Okay. I think we had one more thing we wanted to talk about, and that was a question I think you have for me about
Oh, let me.
estates.
Oh, yes. I'm just
Yeah.
wondering, do you think it a good idea, Ellen, for spouses who are contemplating entering into a marriage contract to also get advice from an estates lawyer?
Well, so I would say, coming back to our earlier comments, that a marriage or common law relationship is guaranteed to end for one of two reasons, either because you broke up or because somebody passed away. These contracts are going to have provisions in them that address either of those eventualities. That if we separate, this is what we do. And if party A dies first, this is what party B gets. And if party B dies first, this is what party A gets. So yes, it's around as a roundabout way of saying that it's lawyers that should confer with estate counsel, wills and estates, not the clients themselves. And I think every one of these contracts should include a consult before it's drafted, before the document's drafted with an estate lawyer to ensure that the process of preparing a new will, where the client or clients didn't have a will until now, or reviewing an existing will in the context of a now new marriage contract where there was already a will in existence, you want both documents to be harmonious and say the same kind of thing about the next steps upon the death of a spouse so that the two contracts and documents work as intended.
I
I,
agree. In tandem.
that's right. And the way you wanted it to. You don't want any uncertainty where one document says something different that the other one doesn't, and the intention of the parties was not um, was
Clear on its face.
was not clear and upheld. And I might also add that where there is a signed marriage contract and where there is a will in existence at the time of death of one of the spouses, and knowing that a will can be changed every single day of the week, 365 times a year if you wanted to, and no one could stop you, that it's important that what you think you want to see in the will shows up in the marriage contract, because if the will gives less than the contract does, the contract trumps and supersedes a will that gives less. So you want to make sure that at least at the time of signing the contract, that an existing will lines up, because it can be changed when people get angry and decide they don't want to do what they said they would do when the contract was signed. But you and I have seen, and certainly on files that we've not worked together, complicated estate wishes that you want to make sure are mirrored in both documents.
Well put.
So
Thank you.
I don't see any questions,
I
but
don't know either.
hopefully what we say made sense.
I do think so. I do have some closing remarks.
Ah,
I just want to say, first of all, thank you to you, Ellen. It means so much to me that you join me in these presentations, and it's always a pleasure, honestly, conversing with you. And as I said, you're my mentor, so I'm just always so thankful and grateful for your presence and your knowledge
I
and
enjoy
all
our
that you've taught me.
conversations. Absolutely, I do.
Thank you. So, thank you to everybody for tuning into Family Law Now. Following the session, a brief survey will appear, allowing you to share your comments and suggestions for future topics you'd like us to explore. Your feedback is greatly appreciated. Book now to take advantage of this opportunity for a complimentary consultation with one of our lawyers. Please contact our intake team at intake, INTAKE, at russellalexander.com. That's RUSSELLALEXANDER.com. And provide the code SPRING 2025. That's in cap letters SPRING 2025 to schedule your appointment. Registration is now open for our next event, How to Deal with Parental Alienation. Just go to russellalexander.com /family law now. Thank you to our panelists, Ellen, for sharing your insight today, and thank you for tuning into Family Law Now After Hours. All the best, everybody. We hope you have a good evening.
Bye bye.